When does the threat of deportation create the right to a jury trial? To find out, you have to read People versus Garcia, but it's 17 pages. Don't have time for that? I've got you covered. This is TLDR, Too Long Didn't Read. Court of Appeals cases in 5 minutes or less. This is the case of People versus Garcia. This can be found at 2022 New York Slip Opinion 03359, published by the Court of Appeals on May 24th, 2022. This is a criminal case. The issue in this appeal, the issue in this case, is when does deportation impact the right to a jury trial for a B misdemeanor or less? This is a somewhat strange case, and I'll explain why in a second. The law in this area is different, and it has changed over the brief period of time. When I was an ADA for 7 years in Queens, routinely when we were in criminal court, if we had an A misdemeanor, a defendant is entitled to a jury trial. Sometimes if we felt like it was not a jury case, if it was not worth the time and expense of impaneling a jury for this kind of a case, or if we thought a bench trial would be better for it, we would reduce it to a B misdemeanor. So we're taking off some time on the table, so the defendant's not facing as much jail time, even if he's found guilty. And if it's a B misdemeanor, it's considered a petty offense, and the defendant is not entitled to a jury. That's how it was when I was an ADA for 7 years. That's before 2018. Before 2018, if it's 6 months jail or less, you're not entitled to a jury. If it's more than 6 months jail, you are. But then in 2018, the case of People versus Suazo was addressed by the Court of Appeals. And that held that a non-citizen defendant, if facing deportation, was entitled to a jury trial, even if it was a B misdemeanor. And the reason why is because the concept of a petty offense is that you're not facing too much time. You're not facing too much of a punishment, so you're not entitled to a jury. But deportation is a very serious punishment. Being excluded and barred from the United States is very serious. And so the Court of Appeals in Suazo said a non-citizen defendant is entitled to a jury, even if it's a B misdemeanor. Then last year, in July of 2022, effective on that date, CPL, Criminal Procedure Law 340.40, was amended, and it now says that any defendant, not just non-citizen defendants, any defendant facing any misdemeanor is entitled to a jury trial. Okay? So this case is not likely to reoccur. This happened to take place at the case of Garcia that I'm talking about took place before the statute changed in July of 2022. It's not likely to be an issue in the future. But what happened in this particular case? Mr. Garcia, the defendant, was observed by a police officer standing on the subway system, masturbating on the platform for about 10 minutes. He then went into two different subway cars and pushed his groin up against two different women. He was charged with A misdemeanors. The prosecutor reduced it to a B misdemeanor, thus taking away the presumption that it would be entitled to a jury trial. The defendant said, I want a jury anyway because I'm facing deportation. And he said, he cited to a specific statute. He said, under 8 U.S.C. 1227A, if I'm found guilty of a crime of moral turpitude, I could be deported. Now, 8 U.S.C. 1227 talks about if you're convicted of two different crimes that are not on the same time, not in the same series of transactions, you could be deported. But he didn't articulate it sufficiently, says the majority. The majority opinion says, so what happened is he asked for this. The judge said no, bench trial. He was convicted at bench. He was deported. And then he appealed, and the appellate division said a trial judge was right not to give him a jury, and it goes to the Court of Appeals, and they say he was right not to give him a jury. And the Court of Appeals says he didn't make out his burden. He didn't meet his burden of proof to overcome the presumption that a B misdemeanor is a petty offense, that there's a presumption that a B misdemeanor is a petty offense, not invoking the Sixth Amendment right to a jury trial. And it's the defendant's burden to overcome that presumption. And here he didn't do it. It goes to the dissent, and the dissent by Judge Wilson says that this particular defendant, Garcia, did as much, if not more, than Suazo did in that 2018 case, and that because that 2018 defendant, non-citizen, made out an entitlement to a jury trial, so too did Garcia. And so that's the case. But once again, you're not likely to see this again because of the change in CPL 34040. That's People versus Garcia. Too long didn't read. Have a good day. If you like what you just saw and want to see more just like it, please hit like or subscribe to let me know.